Hello, sixth formers. Obviously, Mr. Mayer's here doing a bit of a lesson. Like I said, I would try to do one about attempted crime, and yeah, just feels a bit less evil telling you in person, sort of, that there's going to be an assessment at the end of all of this. And I know you just had one as well, so it's even worse. It's just horrible. But yeah, this is just a really short topic, attempted crime. So I know that you've been learning about it for the last couple of virtual lessons at home, and you've been doing your own thing about it. And I just thought that I would go over some of the key points and then get you going on doing an essay question on it, and give you quite a lot of time to do that as well, because we've got today's lesson, which is Friday. I know it doesn't look like it looks like it's the middle of the night, and that's because it is. I'm filming this at about midnight on, well, Friday morning. But you've got that lesson, and then you've got also Monday's lesson as well to complete it. So you can have really think about this attempted crime topic over the weekend, try and get it all straightened out in your mind, and then have a go at the essay. And I'll try and get those marked during the week, ready for Friday. But again, it depends what happens, because we'll see how it goes. But anyway, I thought that I would I know you've looked at the content of the attempted crime unit and obviously done some activities and whatnot. But I think it'd be helpful to sort of talk about it in general terms and think about the nature of the law, and try and give you some ideas about how to go about evaluating this topic, because it is a really tricky area of law, actually, attempted crime, because you've got to sort of think, well, at what point are you attempting to commit a crime? It's not so easy to work that out. When are you trying to do something? When are you attempting to commit a crime? So I've sort of plotted out the different stages of crime here, and just thought that we could just talk about this for a little while, and then I'll revise some cases that you've looked at, and then and yeah, go about making sense of this area of law and trying to make it so that you can evaluate it and talk and, well, write confidently about it. So, I mean, I'm no master criminal, to be honest, but if I was, and someone said to me, what are the different stages of your criminal activity, I'd probably write it out a bit like this. I'd say, well, firstly, you have a thought. You think about committing a crime. You get the idea in your head and think, I'm going to commit a crime, or like, I'm going to rob a bank, or I'm going to kill the Queen, or whatever. And then, because of the thinking about it, you then develop the intent. This doesn't go for every crime, but this is my general thinking on it. And then, once you've got the intention to commit this crime, you then go about preparing for it. If you're a decent criminal, you actually do some preparation, do your homework. So that might involve, not necessarily in the right order, but recon. You'd perform reconnaissance on your bank that you were going to rob, or if I wanted to kill the Queen, which I don't, by the way, she's a lovely, lovely woman. You would then, I'd go and look around Buckingham Palace and see which drain pipes I could climb up to go and bash her head in with a hammer or whatever my plan was. But then that's the next stage, because you could then come up with a plan and how you're going to carry out the crime. And then the plan would inform your equipment. So you think, right, I'm going to do this. I'm going to rob this bank. What equipment will I need? Well, I need explosives to get into the safe. Obviously need a gun to scare the people into giving me all the money. and that kind of thing. So, and then once you've got this in order, this would carry itself onto positioning, because if you're going to commit a crime, you'd have to get yourself in position, get yourself in the place you need to be with the stuff that you need to carry out the offence. And once you've completed all this preparation and made all the plans and decided to do it, then you go on to actually carrying out the crime. You'd actually begin to implement the crime and think, right, we're doing this now, we're robbing the bank, I'm actually now trying to kill the monarch. And you'd actually, try and do it. And then finally, I couldn't quite fit it all in one big line, but I've written this one sideways, you'd complete the crime. So you've achieved the completion of the offence, and you've got all the money and legged it, and your getaway cars got away, or whatever. If it's killing the Queen, you've actually killed Her Majesty. And so it's all of those. So it's kind of like a timeline of things. Now, not all offences would sort of follow this in such a linear way, because sometimes you might do a bit of the recon even before you've thought of committing the offence. So, for example, if I was standing in the queue at the post office and then I saw that there was a till with no one watching over it, or I saw that the security camera wasn't pointing at a certain place, so that's kind of counts as the reconnaissance. You're kind of scoping out the crime. So that might take place before you even think, oh, I'm going to rob this post office. Hey, look, that camera doesn't point at the till, and no one's really keeping an eye on that, and I can see loads of £20 notes in that till. So you might carry out some reconnaissance, and then that would give you the thought, hey, I could nick this stuff. Yeah, I'm going to do it. And then, the preparation on some crimes is really minimal. It might just be an opportunistic, I'm going to go and do that thing now. You get the idea almost at the same time. And then before you know it, quick as a flash, you're actually embarking on the crime, and you've completed it really quickly. So this isn't, it doesn't go for every crime in these absolute steps, and sometimes the prep's really mixed in. Not that I'm an expert on commission of crime, but it's worth just thinking about these different steps, because the law, when it comes to the law on attempts, has to arrive at a point by which we can say, right, that person is now attempting that crime. That's the aim of the law on attempts. It's to make it as clear as possible when is somebody attempting to commit a crime. So, for example, if I just sit and see someone on telly and think, I'm going to kill them, it would be too harsh if you could be punished just for that. So, you can't. That would be too harsh on the defendant. But if there was no law on attempted crime, it wouldn't be protecting society enough, because you'd have to wait for a crime to be complete before you could charge anybody of any offence. So it wouldn't be protecting society if to be guilty of a bank robbery, I had to actually go in, get the money, and then leg it. There's got to be some sort of in-between place. So then the laws found it quite difficult to arrive at that precise position. So, for example, if you could be charged with an attempted offence just for preparing to commit a crime, that would be too harsh. But if you had to, in previous incarnations of the law on attempts, some of the tests included things like the last act test, which meant that you had to have pretty much completed the final action that you could have done to be found guilty of an attempted crime. I just thought to write a little extra board here to try and sort of demonstrate what this is about. So I was just talking about the last act test, and it's not beneficial for society really to have to wait for a criminal to have completed the last act to say that that means that they're attempting to commit the crime, or that they're one step away from completing it. Because in lots of crimes, actually doing the crime or trying to do it doesn't always result in it being completed straight away. With some it does, like we've just looked at burglary, for example, and you might remember that when you're under section 9(1)(a) of the Theft Act, you're guilty of burglary if you step into premises, or even not even get fully in, even if you just get a bit of the way into premises with the intention to steal. So sometimes the line is very fine between starting to commit the offence and then completing the offence, but sometimes it isn't so much. So sometimes actually carrying out the offence is quite a long and drawn out process, and I think the Attempts Act needs to try to strike that balance of, we don't want to wait for criminals to have to done the final thing before the offence is complete, but we also don't want to charge people with attempted crime if they've only at this point prepared for it. So there's a point between preparation and then completing the final act. So I suppose for me, I just like to think about it in common sense language and think, right, it's the Attempts Act and it's dealing with attempted crime. So the key question is, at what point are you attempting to commit the crime? At what point are you trying to commit the crime? And if we set that point as being too early, then we protect society quite a lot, because if even thinking of killing the Queen meant that you could be arrested, Queen is going to be pretty safe, because anyone who thinks, I'm going to do her harm, would be arrested. So she, as the potential victim, is protected to a great extent. But that wouldn't give many rights at all to the defendants, that would all be lining up in court going, yeah, I thought about killing that person or this person, so or committing this crime, or anyone who even thought or intended to do anything would be chargeable legally. So that's why, to preserve the rights of the defendant and also uphold legal principles, which, remember, state that you have to have committed a guilty act to be guilty of an offence, and also that needs to go along with the mens rea. So if you charge it too early for offences, and you can do that, then the defendant hasn't got the rights that they deserve or are entitled to. So the line here has to be sort of drawn at some point. And so the Criminal Attempts Act in 1981 defined an attempt as an act, this is just the actus reus of the attempt, as an act or acts which are more than merely preparatory. So the line has kind of been drawn here. So it's where preparation ends and the implementation of the crime has begun. And at that point, it can be said that you are attempting to commit a crime. Because the word attempt in common sense language can be taken in lots of different ways. Like, for example, if I was going to rob the bank and one of my friends saw me in the bank 2 weeks before the planned robbery, and I was just carrying out some reconnaissance, looking at the cameras, seeing where the security guards were standing and things like that. And one of my friends from uni or something said, "Oh, what are you doing in the bank? Blah blah blah." And I'd be like, "Oh, keep it quiet. I'm just trying to rob the bank. I'm attempting to rob it." the words "I'm attempting to rob the bank" are only true in one sense, in a very strictly preparatory sense, because I'm not doing it now. I'm working towards doing it in terms of preparation, but I'm not actually robbing the bank at this moment in time, or trying to rob the bank at this moment in time. So I'm attempting to do it, but only in a preparatory sense. So the Attempts Act in 1981 tried to define at what point you cross over from preparation to implementation, and so the way it is phrased it is acts which are more than merely preparatory. And the extent to which that is clear is only really known it's still up for debate really, which is what the essay is pretty much going to be about. So you need to be able to look at some cases and think to yourself, right, does the law get it right in these cases? Are these people trying to commit these offences? Going back to the example that I was just talking about, if I then, with my gang of robbers, was actually a week later or 2 weeks later actually walking into the bank to rob it, and with all our masks on and guns or whatever we had, and the same person had happened to come in again and said, "What are you doing now?" And I'd say, "Oh, I'm attempting to rob the bank." The phrase "I'm attempting to rob the bank" would be meant in a much different way than how I'd said it 2 weeks before. I was still, trying to rob the bank and working towards robbing the bank, but on the second occasion, I'm actually in the process of doing it. So I'm attempting to do it, but not in a preparatory way. I'm actually implementing the robbery now. It's game on. We've gone past the preparation. We're now in the zone committing the crime. So if I say here I'm attempting to rob the bank, well, I am trying to. I'm working towards it, but saying it again, I'm attempting to rob the bank, it's meant in a different way here. So it's beyond preparation. We're actually doing it, and I suppose on the cases that we've looked at, or that you've looked at in the textbook, provoke different reactions, I suppose. So let's just go through a couple of the cases, and that will help you to get your ideas straight about whether you think the law's got it right, and whether it's been implemented correctly in the different cases. So firstly, there's two cases really. There's one, Tosti and Boyle and Boyle. Tosti was in 1997. Boyle and Boyle was in 1987. So 10 years apart, but both after the Criminal Attempt Act. And in both of these cases, because they're to do with burglary, the line is a very fine one between preparation and implementation. So, for example, in Tosti it says the defendant intended to burgle premises. He took metal cutting equipment with him, so he's got the equipment. He then examined the padlock on the door and did not damage the padlock, but was found guilty of attempted burglary. So if you think about this one, they've got the equipment, made the plan, scoped it out possibly, got in the position to be committing the offence, and then, having picked up the padlock to examine it, it was judged that they were then implementing, they were then trying to get into the building with the intention to steal. Now at that point, you might think, well, that's a bit harsh, all they've done is look at a padlock. But on the other side of that, how much further do you have to go to actually be trying to get in? If you look at the padlock, are you trying to get into the building with the intention to steal? Arguably, yeah. But Tosti might feel a bit aggrieved and might be thinking, well, no, all I did was look at it, hadn't actually started to try and overcome the lock at that stage. So I was deciding whether or not to do it. But, again, it's protecting the society, the victim, or rights of the defendant. You might think that one was a bit harsh. It depends. This is where essays are good, because it gives you the opportunity to argue on whatever side you think it is right. Another one, R versus Geddes. You may think the law sort of didn't go far enough with this defendant. It says the defendant was found in the boys' toilet block of a school in possession of a large kitchen knife, some rope and masking tape. He had no right to be in the school and was not had not contacted any of the pupils, but his conviction for attempted false imprisonment, basically kidnapping, was quashed. So again, this person had done the recon, made a plan, got the equipment, got in the position to commit a kidnapping, but just because, and they were in the toilet of the school, but because no children had come into that toilet block, presumably he was waiting to grab one of them, he hadn't yet started to implement the offence. Now, again, you might think, well, that's too far, that's too long to wait to not convict that person of attempting to kidnap. You might think that doesn't protect society enough, because imagine if your kid went to that school and you were told that someone had been hiding in the toilets with a knife and some rope to kidnap, and but they weren't found guilty of attempted kidnapping. You'd think, well, something's wrong there, it needs to be tightened up. Preparation maybe should be, maybe positioning should be included in the implementation of the offence. So it depends how you view that one. But again, strictly speaking, in verbal terms, because no students had entered the toilet block, it can't really be said that he had embarked on the kidnapping proper at that stage. So maybe the law and the legal principles and the rights of the defendant, maybe that was the right outcome. He hadn't actually started to try to kidnap a kid. So again, another one, R versus Campbell, is a good one, because in this one the defendant had an imitation gun, sunglasses, don't know why that makes you more likely to commit a crime, and a threatening note in his pocket. And he was in the street outside the post office, but his conviction for attempted robbery was quashed. So again, this person had the plan, equipment, and they nearly was in the position. They were outside the post office, possibly could have been about to go in, but because they were, I don't know the exact details of this case, but because they were stopped outside the post office, they hadn't actually begun to embark on the crime. It hadn't begun to be implemented. So Campbell's conviction was quashed for attempted robbery. Again, think about that one in terms of contrasting it with attempted burglary and Tosti. Maybe those two had done sort of equal amounts of trying to commit the offence, but certain offences are different and have finer lines than others. So to be guilty of attempted robbery, you've got to actually be doing the robbery, and to be guilty of attempted burglary, you have to actually be doing the burglary. But it's just that the point at which you're attempting robbery is later than the point at which you're attempting a burglary. So is it fair across offences to be found guilty of attempting them, but at different levels? So for example, attempted murder, you've got to be actually trying to kill the person. But a lot of the build up towards a murder, not that I've tried to do any, might be really sort of drawn out, and you might be very dangerous even before you're attempting to commit the murder. And the last example of that, or the next example, I think, is the best case for you to remember and know really well, and that is the case of R versus Jones. Right, to help explain this final case, Jones, I've managed to just find an extract from the judgment on the internet, and this case is the best one to use for this, because it really does rest on the very edge of what you could say is trying to carry out the crime and preparing for the crime. So the conviction was for attempted murder. I'll just read out what happened. So it says, the appellant, Jones, got into a car driven by his ex-mistress's new lover. So like he was having an affair with her, but she'd met someone else and he wasn't happy about it, basically. And then he pointed a loaded sawn-off shotgun at him. But the victim managed to wrestle the gun from the appellant in the course of a struggle and threw it out of the car and then escaped. What an absolute ninja. But the appellant was charged with attempted murder, which provided that if, with intent to commit an offence, a person did an act which was more than merely preparatory to the commission of the offence, he was guilty of attempting to commit the offence. At his trial, there was evidence that the safety catch of the gun was on at the time of the attack, and the victim was unable to say that the appellant's finger had ever been on the trigger. The appellant submitted that the charge of attempted murder should be withdrawn from the jury, since the full offence of murder could not have been committed until the appellant had performed at least 3 more acts, namely releasing the safety catch of the gun, putting his finger on the trigger, and then pulling the trigger in order to kill the person. The trial judge rejected that submission and the appellant was convicted, and so he appealed, contending that the correct test to be applied was whether the defendant had committed the last act prior to the full offence being committed, and that the appellant had not committed the last act. So this person has obviously done a lot of preparation. They've figured out where the intended victim was going to be, planned to kill them, equipped themselves with sawing off the end of a shotgun and getting the gun and putting bullets in it and things, and then actually, getting into the car and then pointing the gun at the person. And I think I read somewhere else they said something like, "You're not going to like this," but along those lines. So this case really is on the very edges of what it means to say whether someone is trying to do something or not. So for example, if somebody, let's take it both ways and see. So if Jones had got the gun, walked towards the car, but never produced the gun and not got in the car, maybe we'd say, well, he hadn't quite positioned himself. He was still in the preparation stages. But if Jones had actually fired the gun at the victim, and in some sort of weird matrix way, they dodged the bullet, then you could say, well, they had committed the last act, but they just missed. So then you'd say, right, that's easy. That's an attempted murder. But there's no way that we can know whether Jones would have pulled the trigger if the victim hadn't wrestled the gun away and chucked it away. So this case provides you with a really excellent opportunity to get to the very heart of what the law is trying to achieve here, whether or not preparation was still undergoing. It is actually taking the safety catch off. Should we have to wait for the trigger to be pulled to say that someone is actually trying to kill someone? It would be a bit absurd. I've actually got to demonstrate this, I've got a Nerf gun. So imagine I'm sitting in the car, just like waiting, doing nothing. And then someone who's going to attempt to murder me gets in and they point the gun at me and go, right, I'm going to kill you. And I go, at that point, should they be guilty of attempted murder? For the protection of me, yes, of course they should. But it depends. So should the law wait until because the defendant could at this stage still say, look, I'm not trying to kill you because I'm not actually pulling the trigger yet. I've still got other things that I could do. So at what point do we say that the defendant is attempting to kill me? Is it when they go to prepare the gun to fire? Well, they've still got to pull the trigger to actually be trying to kill me. So in literal linguistic terms, they're not yet trying to kill me. They're just pointing the gun there. Now, if at this point I go, give me that, and then kill them, well, I wouldn't kill them because then I'd probably be guilty of murder or something. But, I could, at that point, they still haven't yet tried to kill me. But by getting in the car and pointing the gun at me, are they trying to do that? Or should I wait for them to actually pull the trigger and say, I'm going to kill you now? Okay, now I'm dead, so it's too late anyway. So obviously, what if they put their finger on the trigger? Let's just reenact that again and pretend I'm not dead. Yeah. So now they've got their finger on the trigger and have not quite pulled it. At that point, if they decided to stop, would that then be not attempted murder because they'd, decided not to do it? Because I was like, oh, really sad about this. So, in this case, it was the jury decided. The jury were asked the question at the point of someone getting into the car, pointing the gun at the person and saying, you're not going to like this. Was a killing happening? Was it at that point that the defendant had actually been trying to kill the person? In this case, the jury said, yeah, there was enough evidence to say that Jones was trying to kill the person there, even though they hadn't actually done the final things. They still had some more steps to take. So again, that's a really good case for you to think about whether the law has got it right or not. So finally, it's time to talk to you about your essay and tell you what the title is. Okay, so this is an essay question that was asked. This is the old format, so don't worry that it says 50 marks. If this question was asked of you now under the new spec, it would be in the final bit and it'd only be worth 25. And it says the Criminal Attempts Act 1981 makes it difficult to distinguish between a person who is merely preparing to commit a criminal offence and one who has put their plan into effect. Discuss the extent to which this statement is accurate. So essentially, you're arguing whether or not the law is clear enough, or is it not? Is it not clear? And try to use lots of those cases that we discussed about what level of actus reus do you have to go to be guilty of actually attempting to commit a crime. Remember the key phrase out of the Act as well. And just give it a go, see what you can do, and I'll look forward to sort of seeing what you've come up with. Don't worry about having to do it today, because I know it's Friday and it's a bit mean because you've just done an essay and I'm saying do another one, but just give it a go, think about it today, ask people and say, look, is it fair that someone was guilty of attempted burglary by looking at a padlock, but someone wasn't guilty of attempted robbery by, actually standing outside with a gun and a note about to go in. Or someone wasn't guilty of attempted kidnapping, they were actually in the toilet of the school with all the stuff to carry out the offence. And just, discuss to what extent is that true? Is the law clear on this when someone is attempting to commit an offence? See what you can do, have a go. Write it during the lesson time on Monday, perhaps, and then have that week to submit it. And I'll try to mark them as they come in that week. And let me know if there's any problems. And hopefully you found this talk useful in terms of talking about attempted crime. Cool, thanks a lot. Speak to you soon. Bye.